Pathways to Reconciliation and Realising Indigenous Human Rights, Treaty, Constitutional Change, Voice to Parliament. This was recorded on the 5th of May 2023. Madison Shakespeare, an academic and scholar at 3 universities at the time of making this, exercises her democratic rights as a tertiary lecturer to debate, discourse, consider different opinions, specifically in regard to lead up to Voice to Parliament referendum 2023. All opinions expressed within this presentation are those strictly and solely of Madison Shakespeare at the time of making this recording. I acknowledge the traditional owners, elders and ancestral spirits of the nations that this lecture was recorded on and delivered to. Australia was, is and always will be First Nations country. In seeking to ensure the social, emotional, cultural and spiritual well-being of Aboriginal and Torres Strait Islanders who are listening to this lecture, please be advised that this lecture contains photographs, film images, voice recordings, names and references of Aboriginal and Torres Strait Islander peoples who have passed. This week we're going to move forward from 1967 onwards, and we're going to start at significant changes that occurred through referendum that impacted very positively on First Nations peoples. You can see here through my annotations the struck out words are changes, amendments that occurred as a result of this 67 referendum. In 2023, again, we are faced with potential change through a referendum. And again, this is specific change that will impact very significantly on First Nations peoples. In 1988, Bob Hawke was presented with this painted declaration requesting recognition of sovereign rights. The Barunga Statement refers to international law premised on human rights conventions. This document specifically calls for the opportunity of First Nations peoples to negotiate with the Commonwealth Parliament in the formation of a treaty. So what is a treaty? Hobbes and Williams outline in their article, The Noongar Settlement, Australia's First Treaty, that internationally treaties are accepted as a means of resolving differences between Indigenous peoples and those who have colonised their lands. They also err toward more holistic definitions of notions of treaty to ensure that First Nations peoples of Australia are not potentially defeated by conflicts of definition internationally, which can arise at times. So Hobbes and Williams provide 3 different scholarly approaches to interpreting the definition of treaty. Formalised records of negotiated agreements between parties, usually states, but sometimes people. Formal and consensual bilateral judicial instruments. And political agreements involving Indigenous peoples and governments that have a binding legal effect. So understanding the holistic and expansive interpretation of the notion treaty that Hobbes and Williams err toward, then we must ask the question, do we have any agreements in Australia that could be called a treaty? Well, both scholars highlight that the Noongar Settlement indeed is Australia's first treaty. They consider the terms of this complex agreement. The settlement is made up of 6 individual Indigenous land use agreements, so ILUASs. And what is of significance is that on the 17th of October 2018, the Registrar of the National Native Title Tribunal announced that she had registered all 6 agreements. On the right-hand side of this slide, you can see some of the terms involved in these agreements, and you can see how complex and expansive in scope they are. For further information about this treaty, Australia's first treaty, you can access the link on this slide and inform yourselves further. I've provided this slide so you can see paths forward from 2018. And so at that time, we had Victoria, the Northern Territory and South Australia engaged in negotiations with First Nations peoples about treaty or treaties. And just in a short amount of time, so in 5 years, you can see now that across Australia, so all states and territories, there are active negotiations in regard to specific treaties for states and those territories. It's important to realise, though, those treaties are not necessarily nationally binding and applicable. And that's why many argue that constitutional change is necessary as well, so that there can be recognition of First Nations peoples of Australia nationally in our constitution. Here you can see 2 newspaper articles specific to New South Wales. I thought that this would be interesting since many of the viewers of this lecture will be located in New South Wales. Position in terms of First Nations realising self-determination through treaty in New South Wales is very dependent upon which government was actually holding power. So here's a situation before the election on the 25th of March 2023, where the coalition, who had the power and control, were very clear that they were not prepared to contemplate treaty. And yet, with a change of government, we can see from the newspaper article on the right-hand side, the 2nd of April 2023, the new New South Wales Minister for Aboriginal Affairs and Treaty lays out plans. So it's very interesting to consider the extent to which First Nations, this country, are affected by who was governing at the time. Is this also a situation that we face in regard to the Voice to referendum that's coming up later this year? In the last slide, I mentioned self-determination of First Nations peoples, specifically Aboriginal and Torres Strait Islander peoples of Australia. Now we're going to look at that further. The Declaration on the Rights of Indigenous Peoples was adopted by the United Nations General Assembly in 2007. It's very important to realise that the Commonwealth Government of Australia did not have to agree to the terms of this declaration, but they did explicitly make a commitment. Their commitment to this declaration was endorsed 2 years later in 2009, and what that means is that the Commonwealth Government of Australia made an agreement with the United Nations to ensure that they would do everything they possibly could to achieve the minimum standards stipulated in the articles of this declaration. Let's look at the articles. Well, 2 of them at least. Article 3 recognises and affirms that Indigenous peoples have the right to self-determination, which entails the right to freely determine their political status and freely pursue their economic, social and cultural development. Further, in exercising this right, Article 4 guarantees that Indigenous peoples have the right to autonomy or self-government in matters relating to their internal and local affairs. In 2023, the Voice to Parliament, the upcoming referendum, is specific to First Nations peoples of Australia, but it is specific to realising the possibility of First Nations peoples of Australia, so Aboriginal and Torres Strait Islander peoples, having a say only on matters that are specific to them. This is really important that everybody who votes understands this. Regrettably, there appears to be so much misinformation there is so much apparent political bullying that is occurring. There is explicit racism that is being generated, particularly in response to First Nations people seeking constitutional recognition. And as I said, very specifically, in regard to what we are looking at in this up-and-coming referendum in 2023, we are seeking constitutional recognition wherein we, as First Nations peoples, have a say only over matters specific to us. Surely this is what the intention of this declaration is seeking. Should First Nations fundamental human rights as Indigenous peoples of Australia be balanced on the precarious premise of which political party is governing? We're now going to consider constitutional recognition at state and territory levels. You have three pieces of legislation here, three constitutions, one of Queensland, Western Australia, Tasmania, all of which are current. And First Nations peoples of Australia are acknowledged and recognised, in fact, in the preamble section of each one of these constitutions. However, it's significant that the contents, anything that is written within the preamble section of an act, is actually not legally enforceable. I'd like to also note that the ACT, as well as the Northern Territory, they both also have their own governing legislation, so in essence their own constitutions. But from what I can determine, neither one of those acts actually mentions Aboriginal and or Torres Strait Islander peoples, First Nation peoples and or Indigenous peoples of Australia, or even in general. Let's now look at three constitutions, New South Wales, South Australia and Victoria. All three constitutions have actually got terms within the body section of each act. Within this section, these terms are legally enforceable and so are very powerful. These are the terms that provide rights. So, the Constitution Act 1902 of New South Wales, you'll see that Section 1 and Section 2 contain acknowledgement of Aboriginal people as First Peoples and indeed acknowledge our connection to country. However, when we look at 3, nothing in this section creates any legal right or liability or gives rise to or affects any civil course of action or right to review an administrative action or affects the interpretation of any act or law in force in New South Wales. So, Section 2, subsection 3 denies First Nations peoples any other claims, any other rights under this piece of legislation. This is a mere acknowledgement and recognition. Similarly, in South Australia, a very similar recognition in Section 2. And there's even an acknowledgement of an apology in Section 2, subsection 2. But then, Section 2, subsection 3, the Parliament does not intend this section to have any legal force or effect. Similar situation arises within the Victorian Constitution Act. Acknowledgement without commitment is like saying sorry and believing that it ameliorates generations of governance that denies Aboriginal and Torres Strait Islander peoples their self-determination. Acknowledgement without commitment to facilitating First Nations peoples' control over decisions that are specific to us, that concern and affect us, prevents us from realising our international human right to self-determination through self-governance. Just briefly pausing and considering where we've got to in this yarn so far. Treaty is possible. We have precedent for that in the Noongar Settlement, Australia's first treaty. And briefly looking at that treaty, we have a situation of place-based specific agreement with traditional owners who are party to this particular agreement. So this treaty within itself is meaningful because of those specificities. State and territory treaties are developing, and there certainly lies potential with those of attaining place-based specific agreements. However, when we look at state and territory constitutional recognition, one must question if it is anything other than token. We have constitutional recognition in the constitutions of New South Wales, Victoria, Tasmania, Queensland, Western Australia and South Australia. But honestly, how meaningful is this for First Nations peoples in attaining self-determination? Does it afford us any power to comment on and be part of legislative changes that directly affect us, that concern us? Where to now then? So how is meaningful constitutional recognition achieved that facilitates Aboriginal and Torres Strait Islander peoples attaining their fundamental rights as Indigenous peoples of Australia? Well, there are many First Nations peoples who will argue that this will not be attained. Self-governance, self-determination will not be attained through constitutional change. And there are other First Nations people who will actually argue that the terms put forward by the Labor government are insufficient and will not realise the change that really needs to occur. However, at this point in this lecture, I'm going to consider aspects of constitutional change and recognition because the Constitution of Australia is our fundamental law of governance. It's the law that put in place the separation of powers. As First Nations peoples, we certainly didn't agree to the enactment and the Constitution being implemented in 1901. We didn't agree with mandating, enforcing the separation of powers. Be that as it may, in 2023, we are living in a system that, yes, it's not our First Nations system, but it is a system that affects us. So being part of that system, we need to have more than recognition within it so that we do have feedback into, input into, control over decisions that are specific to us. And that's something that does not seem to be promoted at the moment. As I said, May 2023, when this is being made. The specificity is critical. So we're calling upon Australian citizens, people who have got the right to vote, sometime this year to vote specifically on matters about us. These matters that concern us have to do with our self-determination and the nature of the system that has been implemented provides all others within the Australian society who are citizens to have power over making decisions that directly affect how we make decisions that are only specific to us. That seems like a profound conundrum because when looking at it in terms of sovereign rights, our business is our business. But regrettably, we are in a system that has been imposed and mandated that is not ours. And because this system affects us, we have to ensure that we exercise every opportunity to have a say in decisions that are actually directly affecting us and nobody else. It seems like an essential criteria or premise so that we can actually achieve our international Indigenous rights. There's been a great deal of, as Trump would call it, fake news. There's certainly been accounts also that have been racist, paternalistic, assimilationist in terms of their approach, their tone, their discussion, and narratives about First Nations peoples. One aspect that has been incorrectly reported on is the histories behind how we got to where we are in 2023, moving toward the Voice to Parliament referendum. Cast your eyes across this timeline. It's only a very brief one, but it certainly shows you that not just the Labor government, but Liberal government, coalition government were involved across decades working toward a referendum. And seeing how many politicians, how many prime ministers of both the Labor and the coalition parties have been involved, set against a backdrop historically of Yorta Yorta Elder William Cooper's letter to King George VI in 1937, in 1963, the Ocala Bark petitions in 1972, the Larrakia petition, and in 1988, the Barunga Statement. We look at what Julia Gillard started in 2010, formation of the Referendum Council, all the way through to 2017, the 30th of June 2017, the final report of the Referendum Council got us to the point where we are at today in 2023. And this council had extensive consultation with Aboriginal and Torres Strait Islander communities seeking constitutional recognition. So, a plethora of stakeholders, First Nations stakeholders and non-Indigenous allies and others, have been involved in this process leading up to this 2023 referendum. This is a snapshot of broader community consultation from the final 2017 Referendum Council report, and you can see how extensive this outreach was. Here you will see the extensive First Nations community consultation that occurred and that culminated in the National Constitutional Convention that was held at Uluru the 23rd to the 26th of May 2017. At the First Nations Constitutional Convention at Uluru in May 2017, around 250 Aboriginal and Torres Strait Islander delegates called on the Commonwealth to establish a Makarrata Commission. Makarrata is a Yolngu word meaning a coming together after a struggle, and the delegates explained that it captures our aspirations for a fair and truthful relationship with the people of Australia. So looking at the outcomes in this 30th of June 2017 final report from the Referendum Council, we can see that there's certainly a great deal of consensus in regard to Voice to Parliament, agreement making, prohibition on racial discrimination. So look at the green sections here. The dialogue's response to the reform proposals as recorded, specifically in the records of the meeting, are shown in this table. It's important also to note that truth-telling is not an option in the table, as it was not in the Referendum Council's discussion paper. However, it was unanimously agreed upon at every dialogue. Understanding the pathways toward reconciliation. We start here at 2017. These are a few excerpts from the 2017 Uluru Statement from the Heart. Our Aboriginal and Torres Strait Islander tribes were the first sovereign nations of the Australian continent and its adjacent islands, and possessed it under our own laws and customs. This sovereignty is a spiritual notion, the ancestral tie between the land, or Mother Nature, and the Aboriginal and Torres Strait Islander peoples who were born therefrom, remain attached thereto, and must one day return thither to be united with our ancestors. With substantive constitutional change and structural reform, we believe this ancient sovereignty can shine through as a fuller expression of Australia's nationhood. This lecture was never intended to give you any directions whatsoever in terms of whether you should vote yes or no, or rather, it sought to navigate you through some of the background behind processes that have been involved and got us to this point in May 2023. There are many who think that this is not their business. There are many who say, well, yes, I'm an Australian citizen and yes, I have to vote, but it actually doesn't concern me. What should we do? It's a really difficult question in many respects, but I certainly reflect on what I do, traditionally speaking, if I face such conundrums. If I'm in a situation where I don't know which direction to go toward, then I'll speak to an elder and I'll try and obtain more information from community. I've had others saying, we don't know what it's about, so what should we vote? Well, yes, as an Australian citizen, you do have to vote. It's compulsory. So I urge you to use your academic literacy skills. Ensure that you understand the significance of everything that's involved in this referendum. Many have also said, we are worried about how this will impact on us. So perhaps we shouldn't change the status quo. Perhaps we shouldn't change how things are now. I certainly say this to you. Consider recommendations from the report. The report was not compiled by one person, it was compiled across a number of years, relying upon evidence that was attained from hundreds of thousands of peoples and a multiplicity of processes. This being the case, go to those specialists who were involved in the consultative processes. See what recommendations they've included in the report that have come specifically from communities. Again, use your academic literacy skills to cut through the white noise of conflicting messages, racism, the assimilationist approaches that seem to be hitting media. Make decisions for yourself. Another really great way of understanding how this perhaps impacts on some First Nations peoples is to consider what it would be like in your context if you were experiencing this, if you didn't have an opportunity to realise your fundamental international human rights that you are entitled to. Now, I'm not saying that this specific constitutional change that is being put forward for referendum this year will achieve all of these measures. Hindsight will gift us with 2020 vision. But I certainly know at this point in time, when we do not have a treaty or treaties, other than one treaty in Western Australia that is not relevant to me as an East Coast Aboriginal person. I look and I see that we do have potential for having treaties because we already have a really large treaty enacted and operational. So there is scope for treaties. There is scope for constitutional recognition because that's already happened across most states in their constitutions. However, if we're going to have constitutional recognition, it needs to be meaningful. We need to be able to attain self-governance in terms of self-determination. We need to have the ability to have a say about legislation that is being made about us by the Parliament. That's fundamental. Right to speech, right to say, how it affects us. Now, whether that be realised through a treaty or treaties and or constitutional changes and or administrative restructuring, that's a whole other lecture. But I urge you all to use those academic literacy skills. Go and become informed. Hear from First Nations peoples who are directly affected by the Constitution as it is at the moment, and potentially what constitutional change may mean for them. Thank you for listening.